My name is Bianca Tavolari. I'm a legal professor at Fundação Getúlio Vargas in São Paulo, Brazil. I'm also a researcher at CEBRAP, which is the Brazilian Center for Analysis and Planning. And I'm also a principal investigator at Mecila, Maria Sibylla Merian Centre. And right now I am in Berlin for a research visit that is taking place in June and July of 2024.
Maybe we can start by you giving a brief introduction and overview over the student protests in 2015-16.
This research is mainly based on the public school occupations that have happened in São Paulo in between 2015 to 2016. So only that we get the context out of it, there were 213 public schools that were occupied by their own students. This happened right after the students first took the streets in protest, and when they saw that it wasn't doing anything, they changed their strategy and they started to occupy the schools and to build a self-management of the whole occupations during several days and weeks. So this happened firstly because there was a very specific public policy, educational policy, that was trying to reorganize how high school was working in São Paulo, and then 94 schools were going to be closed. This was led by the governor at the time, Geraldo Alckmin. For the people who don't know Brazilian politics, we're not familiar with Brazilian politics. Right now, he's the vice president of the third Lula government. So this is kind of a plot twist in between the story. Like reading from it now brings us several new layers of interpretation. But sticking to 2015, 2016, 8 years ago, so this massive protest happened, and the public schools were occupied, and this was probably the first massive high school demonstration that we had, and it was then known as the High School Spring, in order for it to echo like all the springs that have come before in the history of protest.
Yeah, maybe you can also say a bit more about how this wave of occupations is also connected to like the broader movement context in Brazil and the role of occupations.
We have land occupations. I mean, we have one of the biggest landless movements in the world. It's the biggest social movement in the world, MST, Movimento dos Trabalhadores Sem Terra, the landless movement. But also occupations are kind of the grammar of protest. So movements who are not discussing property or private property in itself also use this repertoire, this tactic to occupy public buildings or even private ones to raise awareness to their banners, to their flags, to their slogans, to their reivindication of rights. So this is not new in Brazilian history. What is new is that it happened to schools, that the schools have been occupied for quite a reasonable time, because we had a very different legal reasoning by the São Paulo Court of Justice. So this is kind of an outlier in this whole discussion. It is massive, and it is also an outlier, and we believe that in the text we try to show that we have to combine a very different lenses for us to be able to understand what happened and to understand why it was so successful in a way, but also has provided a leeway for a lot of state violence as well.
What are like usually the legal reactions to these kinds of protests? What was different in this case?
So the first thing we're talking about public schools, and in Brazilian legal system, this means that they are part of state property. So when the students occupied public schools, they were occupying state property. So the state is the owner. So the first thing that an owner is going to do in Brazil, in Brazilian legal system, they are going to file a lawsuit. It's not possible until this case to ask directly for the police to take people out, because otherwise you would violate a series of fundamental rights. So the more prominent or the more frequent way to do that, to evict someone, to forcibly remove someone from your property, is to file a lawsuit. And this is called a repossession lawsuit. So in Brazil, they are very fast in order for property to be regained and repossession to be regained. And also in our Court of Justice in São Paulo, you have one way of building the reasoning, which is the owner being taken away from their property and repossession? Yes, no, can we prove it? And if so, then the matter is settled. So it's a very fast-track procedure, and also there's not a very complex legal reasoning in it. It's the very structure of this lawsuit. So what happened here is that what usually happens when we're talking about occupations as a grammar for protest is that when it comes into the judiciary, it's being depoliticized in a sense, because protests, and this specific protest, was not about who should own the public property of schools. The protest was occupying schools in order to raise awareness to the specific proposal by the governor that was going to rearrange the whole high school system. So it was about education, it was about participation in public policies, it was about rights, but not about property. So when it comes to the judiciary, to courts, it becomes a matter of property and repossession. So the students are anonymous invaders that are taking public property and making it private in a sense. This is the lens that the Court of Justice is going to look at. What happened here is that first, when the lawsuit came to court, the students were not recognized as subjects. So they are only going to be recognized as subjects because of a public hearing inside the court. So this is the first thing that's different. When the students were heard inside the judiciary, the whole legal reasoning from the judge changed. So the judge suddenly recognized the students as subjects because he thought that they were being manipulated by the unions, the teachers' unions, that there were other political parties that were actually inflating the occupations. And when the judge suddenly realized that there were the students organizing, he suddenly recognized it as a legitimate claim. But then also he said, this is not a matter of repossession, this is a matter of freedom of expression, manifestation, and also the right to education. So inside a very specific and standardized legal reasoning that is brought out by the specific repossession lawsuit, they inserted new variation of legal arguments saying we're talking about something completely different. We're talking about the right to protest. So this is also different. And so we had the São Paulo Court of Justice, which is recognized for being very conservative in terms of property law, recognizing that the students could stay because it was not a matter of who had the ownership or who should possess public schools, but rather a discussion of closing schools, reallocating students, making several students lose their right to education. And so this is a first-timer.
Maybe you can also say a bit more about like what the political reaction then was to this, of the São Paulo government, and what was at stake in these conflicts in the arenas of the public, the law, and the political struggle.
Sure. So the first thing is that the governor didn't do anything regarding the protests until the students occupied the schools. So because several other protest forms were tried before. And then here is also interesting because there is an inspiration in between Brazil and Chile, because there was before, a couple of years earlier, the La Revolta de los Pingüinos in Santiago in Chile, and in which public schools were also occupied. So the students in São Paulo took this repertoire from Chile and decided to occupy the schools. And this was also interesting because it mobilized a very vast public in favor of occupying the schools. Because I mean, when you think public schools are going to be closed, and then the students decide to self-manage it, and they have started to do things like free classes, and they would invite a lot of teachers, but also celebrities to come into the school and give a free class. So they were like very high celebrity chefs that gave gastronomic cooking lessons inside the schools. So it became a common place that was organized by the students. So we had a poll, a survey in São Paulo, and public opinion was very much in favor of the movement. And Geraldo Alckmin, the government, his popularity fell. So the Secretary of Education also had to leave his office because of all of that. But what happened is the governor did not expect for the judiciary to rule against government. So this was kind of a big surprise. And this is where the strategy comes into a new phase in which the state decides to bypass courts. So they start to build a legal reasoning saying that since the state is the owner of the public schools, and in an analogy with the private owner that may, in the Brazilian law, for a very short period of time, use their own forces, the state could also do that. So the state would not need any institutional intermediation to take people out. They could only use the military forces in their favor to take forcibly the students out. So then it becomes a very sophisticated legal reasoning for taking people out without any intermediation. And the justifications that were brought are authoritarian in itself, because they're saying it's like the state has a superpower. It doesn't have to be, it can exclude courts from legal appreciation, from legal scrutiny. It can exclude their acts from being controlled by other powers. And this is also a new thing that happened here. It's not that the Brazilian government and the Brazilian police doesn't do that. They do a lot. People are being forcibly evicted and forcibly taken away from property all the time. But what is new here is that they ask for a specific legal justification. They wanted to build a new standard in which judiciary was not necessary anymore.
You also described this escape from the judiciary as an opening into authoritarian rule. Would you say that it did contribute to like a wider development?
It was very effective. I mean, even if we discuss in details the legal reasoning that's there and how it is authoritarian, why it takes away democratic control and public control from the acts of the executive, but it was very effective. First, because the occupations have ended in the beginning of 2016, because students were victims of extreme violence. So the first thing is it ended the occupations and the protests. We had another wave of school occupations in the midst of 2016 in whole Brazil because of another reform, but this one a federal one that would impact all the states. And for instance, in the state of Paraná, more than 900 schools were occupied. And when you look in the same wave at São Paulo, no school was occupied, because even if there was an attempt to occupy, the police would already be there. So they did not have the possibility to negotiate the justification of occupying schools. It was already interrupted from the beginning, so it was very effective on the years to come. And this is also interesting because the authoritarian legal reasoning that was constructed was promoted by the then Secretary of Public Security, Alexandre de Moraes, who then became the Minister of Justice, and then one of the justices of our Supreme Court, who is until right now one of the justices, one of the most famous one, especially regarding Bolsonaro, and also everything that the Supreme Court had to do with stopping some of the most severe Bolsonaro initiatives during the 4 years of his mandate. But here we had someone who was saying we do not need the judiciary or the courts to say anything about taking violently people from protesting in public schools. That then shifts.
Would you say there are other effects that you can still see in recent protests or recent events that are important long-term effects?
There's some. Like when we're talking about the public schools, we're also highlighting what happened after our June protests of 2013. So there is a very mainstream interpretation of the massive protests in Brazil in June during Dilma Rousseff's government, the Workers' Party president that was then removed, saying that this was the beginning of the extreme right, that putting it together, linking it directly to the extreme right. And one of the things that we are highlighting looking at the school occupation, saying, well, wait a minute, there are a lot of things that have happened in between and that they're not by the extreme right, in the sense that the extreme right, only the extreme right took the streets. We are talking about students that are mobilizing for public good, for taking their schools, for them not to being closed. So, and they are also operating in a very interesting grammar of protests as well. So this is one thing which I think is very, very important, because right now in the retrospective, a lot of people are saying this all started in 2013, and then we have the extreme right all over. This was the reason for Dilma Rousseff to be taken out of power and so on. So this is for Brazil. This is also important to highlight what happened in between. This is not the only thing that happened, but it's a massive movement that is generally forgotten.
Would you say that this is generally a risk if you frame political demands and political protest in legal terms, that there is a risk of it becoming depoliticized?
The language of rights is an open language. This is the first thing that we have to understand, because law is subject to interpretation. This doesn't mean that it is subject to any interpretation. We can have like 15 different interpretations of something, but not any. So, but the first thing is that when it comes to courts, you have to translate the grammar of politics into the grammar of rights. So when we are talking about the occupied schools, this happened in a way that silenced the protest. It didn't have to be like that. So this is the first thing. So it's not only language of rights, do we have it or do we not, but how? So this is, I think that, and the how is not a fixed meaning. The how is a dispute. So a dispute of interpretation. I think that the case is also very interesting, because when we didn't have people here that were promoting litigation. They were not trying to discuss anything about property law, and they ended up bringing about a variation in legal reasoning without even wanting. Think, for instance, squatters that are occupying empty buildings in São Paulo's city center. They are wanting to bring about different legal reasoning on the social function of property, because they are saying, well, we have in the Brazilian constitution the right to private property, yes, but also the right to social function of the property. And if the state is not bringing the social function of property, we are doing it with our own hands. So we are actually following the constitution. So they are trying to bring legal reasoning, which is not only directed to courts, but it's also directed to the public sphere, because this is a battle of justifications when you're talking about protest combined with property. And protest, when it comes to occupation, it is always going to be combined with property, be it public or private. So when you start an occupation, you start a battle of narratives, and the narratives are obviously rights related, although it's not directed to the legal system as such. So this is the first thing. It is an open language. The how matters, and it is a dispute. And in the sense, it can be a democratic dispute. It doesn't mean that a democratic dispute says that everybody that's litigating or being into court is going to have an equal standing or equal right in order to frame their legal capacity. This is not the case. So this is the first thing. The other thing that we need to have in mind is that there is a lot of selectivity when it comes to far-right protests and movements, especially when we had an authoritarian government such as Jair Bolsonaro with authoritarian protest. So they did not enforce the right of state ownership. So it was completely different, although the far-right movement also proclaimed itself saying, we're not criminals, we're not invading, we are taking back what's ours. So their public justification also was part of a language of rights. What I think it's important is, obviously, we are in a terrain in the language of rights which it's not secure. It's not a guarantee that we will have progressive outcomes, but in any political process that is also the case. But what is important for us to recognize, I believe, is that when the extreme right, the far right, is taking a language of rights or is talking about democracy and not explicitly being against it. Of course, they are being against it in the substance, but when they're saying that they're in favor of democracy, we should take it seriously. Not because they are pro-democracy as such, but that changes the game, because then they pose themselves as contenders of a dispute inside democracy, which they are not.